Last study. Start. This quote, while reiterating that no aspirant has a vested right to claim compassionate appointment, declared that the norms that are in force when the application is actually considered will be applicable. The employer's right to modify the scheme depending on its policies was recognized in this judgment. Noticing the extinguishment of the right to claim appointment, this court held that dying in harness scheme, which was prevalent on the death of the employee, be the basis for consideration the necessity of resolution of the conflicting question on whether the norms applicable on the date of death or on the date of consideration of application should apply. The dependent of a deceased government employee are made eligible by virtue of the policy on compassionate appointment, and they must fulfill the norms laid down by the state's policy. Applying the law governing compassionate appointment culled out from the above cited judgments, our opinion on the point at issue is that the norms prevailing on the date of consideration of the application should be the basis for consideration of claim for compassionate appointment. The dependent of a government employee, in the absence of any vested right acquiring on the death of the government employee, can only demand consideration of his/her application. He is, however, disentitled to seek consideration in accordance with the norms as applicable on the date of death of the government employee. In view of the foregoing opinion, we endorse the tribunal's view as affirmed by the High Court of Karnataka to the effect that the appellants were ineligible for compassionate appointment when their applications were considered, and the unamended provisions of Rule 5 of the rules will not apply to them. Since no infirmity is found in the impugned judgments, the appeals are found devoid of merit and the same are dismissed. Therefore, the object and purpose of the Act also provides that a town development scheme can be prepared in the presence of a zonal plan, which is in turn has to be prepared for the implementation of the development plan. If the aforesaid aspects and the defense amongst the plans are kept in mind, it is lucid that the High Court has misconstrued and misdirected itself by relying upon the principle of promissory estoppel to hold that once the layout plan is prepared, the same cannot be modified or changed. Change or modification is permitted under the provided, and modification change is in accordance with law, that is, as per the procedure, and satisfies the development norms and conditions of the development plans, zonal plans, and town planning schemes. The modification cannot be struck down when the law permits such change, which is in terms of the statute and the plans that have the force of law, as long as the layout plans conform to the development control norms. The court would not substitute its own opinion as to what principle or policy would best serve greater public or private interest. It is not the case of the first and second respondents that the procedure prescribed by the adhiniyam was not followed or the parameters and norms prescribed by the adhiniyam. The development plan or the Jolan plan have been violated. In this background, we fail to understand how the modification in the layout plan, which is in accordance with the adhiniyam, could have been struck down. On facts and justification for change of land use from commercial to residential, the impugned judgment ignores and glances over the earlier position that the area was earmarked for development and for construction of a shopping complex with 131 shops and not earmarked as an open area, park or playground. It is an undisputed position. The land earmarked for the shopping complex had not found demand and takers despite efforts. The area was lying idle for more than 20 years, albeit more than 150 shops had already come up in the residential area. As per the appellant board, construction of 131 shops would have caused congestion and would have adversely impacted the density of people living and using the area. We have highlighted these aspects and facts which are vastly distinct for the courts normally frown upon, adversely comment and do strike down changes in the land use from residential to commercial or industrial use for obvious reasons. The writ petition challenging the orders was filed in 2015, nearly 7 years after the approval for modification was granted. In the meanwhile, 42 out of 52 plots had been sold to third parties for consideration. The impugned judgment notices that many of these bona fide owner purchaser had completed the construction and some houses were in advanced stages of construction. While the High Court has noticed and recorded these facts, it has failed to give due credence to the delay, the change in position and creation of third-party rights while wrongly applying the principle of promissory estoppel and its pendants. Innocent plot owners on whom and warrant had fallen were not even heard before they were deprived and denied their rights by the adverse order. Considerable delay and lapse of nearly 7 years in approaching the court had resulted in change in position as third party rights had been created. In view of delay and lapse, the High Court should not have entertained the writ petition as 42 plots owners who had paid money would suffer adverse consequences for no fault of theirs, that the High Court in exercise of its discretion does not ordinarily assist the tardy and indolent or the acquiescent and the lethargic. If there is inordinate delay on the part of the petitioner and such delay is not satisfactorily explained, the High Court may decline to intervene and grant relief in exercise of its writ jurisdiction. It was stated that this rule is premised on a number of factors. The High Court does not ordinarily permit a belated resort to the extraordinary remedy because it is likely to cause confusion and public inconvenience and bring in its train new injustices, and if writ jurisdiction is exercised after a stop,